For everyone else, they will jot the notes down second. So let's think about the context. Last lesson, we talked about this issue. We talked about the fact that when people get arrested, the police have special powers. There's an act that gives them those special powers. And things that have to happen. The police has to give some identification information about themselves, but the person who's being arrested doesn't have to give any special information. They can be then taken, they're charged, they're told what they've done wrong, what law they've broken, and then after they post bail, provided they don't pose an extra threat or a risk of not showing up for court, they'll be allowed to go with bail and come back with their court hearing. And remember, there's the special condition that says you have a right to silence. You don't have to say anything. And that's something to keep in mind if ever you get in trouble with police. So we now go from that arrest process to say, what's the next part of this process? Okay, and we're talking about the court system. If it's a serious matter, we start with what is called a committal hearing. And this is a smaller trial, and what it looks at is just that there's enough evidence for the trial to proceed. Let's say, again, I've been accused of stealing my neighbour's boat. If we get to the stage where the police pull me in and say, take me to court, they have to prove they've got enough evidence that it's reasonable that I stand trial. If all they've got is a picture that doesn't really have any details in it, that's all the evidence, then the process won't go any further. And that's taken place in the magistrate's court. That's the lowest court. Checking if there's enough evidence on face value for a trial to proceed. That's very important. We then move on to where would the trial be held. And so there are three different courts, and we'll come and have a look at these notes in a bit more detail. Just going through them now, the bottom court, the lowest court, the court we visited last year is the magistrate's court. And that hears minor matters. Maybe someone's disputing a speeding ticket. That sort of small thing, a minor assault, a small theft, would be heard in the magistrate's court. We then move on up to the district court. They hear matters where the maximum penalty is less than 14 years. Let's say I assaulted someone on the weekend and the maximum penalty I was facing was 10 years. That would be heard in the district court. And then the third court is the Supreme Court. That deals with matter with a maximum penalty of more than 14 years. So the Gerard Baden case, where he was tried for murder, first of all, there was a committal hearing in the magistrate's court to check there was a reasonable amount of evidence for a trial to proceed, but that went to the Supreme Court because he was facing life in jail. So they're the three courts you may end up in. On top of that, if you've had a trial in the district or Supreme Court and the jury has found you guilty, or they found you not guilty and the prosecution want to appeal, there is another court that people can appeal to. And if a mistake has been made, if something's been left out of the case, another example of mistake, for the Daniel Morecambe murder, they took all the jurors, the 12 people on the jury, plus the couple of reserve jurors they had for that case, they took them out to look at the place where Daniel Morecambe's remains had been found. And even though they had police clear the area and make sure the jurors weren't exposed to anything they shouldn't see, someone had left a note in that area, kind of along the lines, make sure you find this bloke guilty. And juries shouldn't be exposed to that. So there was some question to say, well, should the trial have been allowed to proceed? It was allowed to proceed, he was found guilty. But that might be something that someone appeals about. Yeah. Yes, yeah, the note was definitely seen and found by the jury. Yeah, otherwise it wouldn't have mattered so much. Just the jury who were taking that special trip. Yeah, yeah. So there you go. That's the Court of Appeal, and it's made of 3 to 5 judges. It's not a jury that decides this time. 3 to 5 Supreme Court judges, the highest court in the land, they make that decision. And you can't just automatically appeal. Let's say I had my trial in the district court where I faced, say, an assault charge with a maximum penalty of 10 years, so it would be assault that caused harm for someone. In that case, I can't just say I want to appeal it. I have to have reasons that the court accepts for me to appeal. You can't just appeal willy-nilly. And the last thing, talking about a couple of the key people involved in a criminal process, you looked at some of this research. We looked at the judge, and I want to compare on this slide the judge to the magistrate. So the judge, they oversee the proceedings of the court. They check that everything runs. So judge you will find in the district and the Supreme Court. They check that the rules are adhered to, and they make the sentence. If I'm found guilty in the district court of my assault that caused harm, the judge will be the one who decides I get 2 years in jail or 4 years in jail or whatever. In the magistrate's court, a magistrate is responsible for both the verdict, guilty or not guilty, and passing a sentence. So they have some extra responsibility there, but remember they're dealing with smaller matters.